Mr. Speaker, sir, my honorable colleague here on this side, Mr. Stephen Yong, this morning had dealt with the legal aspect of the amendment, which this bill seeks to make in the federal constitution. I think he has said enough, to show how dangerous it is for this House, to agree to these amendments, because once again, the House is called upon to tamper with the state constitution. Honorable members may remember, that on a previous occasion, the House was also asked to make amendments to the Constitution, and the legality of our action was challenged in the court of law. And the House would have been placed in a very embarrassing position if their lordships in the Privy Council had decided otherwise. Sir, I merely wish to express the feelings of a large number of citizens in Sarawak on this matter. It is generally known, sir, that the Inter-Governmental Agreement provides for direct elections in Sarawak when the term of the present legislature or council negri expires. The government knows, just as well as anybody else, that this is the position, and one wonders why early steps were not taken to make the necessary arrangements to comply with this agreement. We, in Sarawak, know that the British officials who remained after Sarawak entered Malaysia, went to all the trouble of making research and providing facts and figures from the electoral rolls of the local councils, to find how best Sarawak could be divided into constituencies for the purpose of direct elections, and all the result of this work was put at the disposal of the Election Commission. The Election Commission was rather slow in the first place, in going to Sarawak to take up the work which is necessary. Nevertheless, they did their work in time, and honorable members will remember that from time to time we on this side of the House, had pressed the government to take some action, so that elections could be held in Sarawak in time, and in strict compliance with what is laid down in the Inter-Governmental Agreement. Nevertheless, the government does not seem to pay enough attention to it, and in one session, I even suggested to the Honourable Deputy Prime Minister, that if action was delayed much further, I was afraid, amendments would have to be made to the federal constitution. He said he was not sure of that, but now we have here a bill, which shows that what I said was in fact correct. Now, sir, things being as they are, we concede that amendment to the state constitution is necessary. We in the SUPP concede that, and therefore we have in fact, agreed to a suggestion put up by the Sarawak Alliance, that an all-party conference should be held to consider what amendments are necessary in order to carry out the provisions of the Inter-Governmental Agreement. But although we have expressed our willingness to cooperate with the government, no such meeting was held, and constant reminders to the government produced no result, and we are now confronted, not with an amendment to the state constitution, but with an amendment to the federal constitution, which virtually, as my honorable friend pointed out, violates and tampers with the state constitution. Sir, we in the SUPP cannot condone this by being party to such action. If an amendment to the state constitution is necessary, the state constitution provides for how this may be done, and the proper thing to do is, for this to be carried out by a bill in the state legislature. We do not wish to be obstructive, and we can assure the government that if such a step is taken, it will have our support in that House, but we cannot be a party here, to the tampering of our state constitution by the federal government, because, if we do that, where is this going to end? The Constitution contains safeguards which protects the special rights and special position of Sabah and Sarawak. If we allow this to be whittled away by amendments to the Constitution in this House, we might as well have no Constitution at all. To us, the Constitution is sacred, it is a sacred document, we cannot allow it to be tampered with, at whims of the government to cover its sins of omission, its inaction, over a long period in carrying out its obligations under the Inter-Governmental Agreement. By trying to circumvent the state legislature by virtually forcing the state legislature, whether it likes it or not, to make amendments which it would perhaps be willing to in the first place. For that reason, sir, we in the SUPP cannot support the bill as it stands. If the bill is formulated in such a way, had it merely enabled the state legislature to carry out the amendments, it would heartily have our support. In our view it goes much further than that, sir. It virtually amends the state constitution through the back door, and we cannot be a party to this, sir.